Your Honor is willing to recall this at 3 o'clock on the motion docket.
Do you have a copy of the report, counsel?
Yes, I was given a copy.
So everybody's got a copy but me.
Hear me. Yo, watching how them opera boys get sentenced. You know how the fuck's going on. Man, y'all boys tuned into that Oouchie court watch. Well, we taking it straight from the jail cell to the judge. Hear me?
Court does call the case People versus Cameron Jones.
Carolyn Foster Tucker on behalf of Mr. Jones, who is approaching.
Tamarion Jones.
Tamarion Jones.
Tamarion Jones, sorry.
We are requesting an exam in this matter,
Discovery is complete.
to my knowledge.
People have their witnesses available the 19th.
We will try our best, Your Honor.
Preliminary examination. In person, August 19th, 2025, 9 a.m. That is before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Oh, Your Honor, well, that's okay. He had a bond violation with the new case. So there was a request.
Is a bond violation in this case?
Yes. The last time Mr. Jones appeared in court, apparently there was an incident either that day or the day right before that. And there's a new case with the same victim that is authorized out of 14B. And we just get information from her that she is requesting a remand if possible.
Who is requesting a remand?
The victim in this case, same one in the new case, which is Mr. Jones' mother.
Do you know anything about that?
Your Honor, I was made aware that there is a new case. I believe it's set for an arraignment or is being set for an arraignment in 14B. Mr. Jones does deny the allegations, and
I don't have anything. What is the violation?
I emailed the court about it. It was apparently Mr. Jones went when there's a no-go to and a no contact order with his mother, went over there. Is it another NDOP? It's another.
Is there a police report? Guys, I have nothing.
I understand that, Your Honor. I did send it to the court.
To which court? Us?
Yes.
When?
I believe it's July 18th. If Your Honor is willing to recall this at 3 o'clock on the motion docket.
Do you have a copy of the report, counsel?
yes, I was given a copy.
So everybody's got a copy but me.
Oh, July 25th. Yes. July 22nd, rather. I got the response from the court.
You sent it to Miss Widely?
I did.
Resend it.
Sure will.
We don't. All right. Well, here's what I'll do. I'll pass this matter briefly and then make a decision as to whether or not I'll hear it now or I'll hear it at 3 o'clock.
Thank you, Your Honor.
Okay. So, sir, you must remain here in the courthouse. Understood? What?
Yes, sir.
Thank you. Court calls case People versus Gregory Bell.
Carl Bell on behalf of Mr. Bell is approaching the podium.
Good morning, Your Honor. Gregory Bell.
Today's a date and time set for a probable cause conference. We have tendered a plea form to Your Honor. We'll be entering a plea today. I also have an assigned advice of rights form.
I have a plea form that indicates that the defendant will be pleading. I don't have what his plea is going to be. I'm assuming it's guilty.
Yes, Judge.
Sir, are you having a problem hearing me?
I was a second ago, Your Honor. I just needed to lean in a little bit. I got bad ears. I'm a vet, and I fired too many weapons when I was in the service.
Okay.
I just have a little trouble hearing. Usually, if I lean forward, it helps.
Well, we've got some equipment that might help you. So why don't we try that? Okay.
Okay. Sorry.
What brand?
I was in the Army and the infantry.
Were you?
Yes, sir.
Fantastic. How many years you served?
A little over 3.5.
Is that better, sir?
Much better. Yes, Your Honor.
Yeah. Okay. So I have the plea form indicates the defendant will be pleading. Is it guilty?
Yes, Judge.
Will be pleading guilty to failure to return rental property 200 to 1,000. That's a 1-year offense. And then upon his successful plea to that charge, count 1 would be dismissed. There further is an agreement that there would be no upfront jail, although I can't bind the sentencing judge to that, and a delayed sentence.
Yes, Judge.
Does Judge Washington do delayed sentences that way?
I'm not sure, Judge. We talked about a prosecutor's deferred with Mr. Banis, but I believe what's our part? Yes. I believe she does, Judge, but she does.
Under 7741, 7771, or does a delayed sentence, or does she do deferred sentence? Okay, but that's not what this form says.
I believe the prosecutor's deferred is under 7711, is it not?
Actually,
Not the same.
technically, no.
Technically, no.
But what is the intent of the parties?
The intent basically is to have it, basically to earn the deferred sentence, to have it dismissed upon completion.
Then give me a
Correct
right
form.
form. I'll
Understood.
call it back up.
Thank you, Judge.
All right, thank you. Court call case people versus Marcus Jones.
People. This is Marcus Jones. Is this Marcus Lamar?
Oh, there are two Marcus Jones?
I think so.
Yeah, that's right, because we have two torso features.
I'd be shocked.
I did, you know, we have two torso features. In fact, yesterday I called your name, expected to see you. It was another torso. You know, it was incredible. It was incredible. He was bald too. Just so you know. That's what they do.
Is this Uncle's name?
Okay, so let's make sure that I was informed we had two Marcus Joneses, one that does not have a middle initial and one that does. Do you have a middle name?
Yes, sir.
Okay, what's your middle name?
Deshaun,
Give me your date of birth.
0503-2004.
0503 2004.
Yes, Your Honor.
Okay, this case is him. Right here, Marcus Jones. No, go.
I heard it in there.
No, I figured it out.
There are two torso
Course,
pieces?
two torso features. We got it all straight. I think the other feature I locked up. Something went wrong. All right.
There actually are two Sam Bernstein, so.
There are, but we got lucky. Okay. So,
Correct, Mr. Jones, we're hoping for an adjournment to obtain a review discovery, Your Honor.
all right.
Your Honor, people may respond when appropriate.
Pardon?
When people respond when appropriate.
Okay. I will adjourn this then to the 28th. Probable cause conference, August 28th, 2025, 9 a.m. As to bond,
Your Honor, the bond is currently set, I believe, as $10,000 cash or surety. The people renew their original request of $50,000.
of how much?
$50,000 cash or surety. The underlying offense which charges an attempt armed robbery is set to submit an amended complaint of assault with intent to rob while armed, the more severe felony. The factual background here concerns for public safety. When law enforcement did a search warrant of the defendant, the co-defendant's home, they found a stolen block handgun, 3 additional firearms, including parts and materials to convert a gun to be fully automatic. 2 of the additional firearms were stolen. 1 was not registered to anyone. Both this defendant and the co-defendant have prior weapons-related offenses under HIDA. So I'm concerned for the public safety. I think the $10,000 was an abuse of discretion. That $50,000.
Response.
Somewhat handicapped coming in because I'm jumping into this case recently. I only received discovery last night, so I haven't had a chance to review it. It sounds like the people intend to file a renewed complaint that changes the charges, and that's part of the basis of the request. I would ask if they are going to file such a complaint that could go along with a motion to address bond, and we could do that next week. And I could be more fully prepared to understand what the argument is.
There's a co-defendant in this case.
Yes, Your Honor.
What's that bond?
It's also set 10,000. I'm going to make the same request on that case when it was called.
Is that one going to be amended also?
Yes, Your Honor.
Okay, so in that individual's in custody?
Yes.
So why don't I have an amended complaint now?
I have not had the opportunity to prepare that with final.
And you don't have the discovery yet.
I did receive discovery last night, but I haven't had a chance to
Can't
look
have
at
a
it yet.
chance to go through it. So at this juncture, what I'm going to do with reference to this case and the other, I guess the co-defendant's case regarding bond is I'm going to deny the request without prejudice. You file your additional charges and then we can hear it at that point in time and give counsel an opportunity to see it.
Understood. Thank you, Your Honor.
So at this point, bond will continue.
Thank you, Your Honor.
Talk to you soon.
Court calls case People versus Anthony Williams.
Morning, Your Honor. James McWheel, Special Assistant Attorney General on behalf of the people.
Assistant Public Defender Chelsea Vergils on behalf of Anthony Williams, who is in custody.
Anthony Williams.
Thank you.
Your Honor, we are asking for an adjournment, and when appropriate, we would ask to address bond.
Purpose of the adjournment,
Just to continue a plea discussion.
August 28th, 2025. You said that the victim in this case is here?
Correct, Your Honor. Yes, she's here now.
Mr. Attorney General, did you indicate to the victim or payee in this case or that she was supposed to be present at this hearing?
I don't believe anything specific, Your Honor, but naturally the victims or custodial parents are apprised of all court proceedings, so I suspect she's there voluntarily.
Okay, all right. I didn't, okay. Well, where is she? Is there something you wanted to tell the court, ma'am? It's a bit unusual at this particular point in the proceeding, but no, you just are here today. Okay, that's fine. Welcome. All right. All right. I just wanted to make sure I wasn't ignoring anybody. All right.
Regarding bond, Your Honor.
Yes, well, let me finish this. August 28th, 2025, 9 a.m. for the probable cause conference. Yes, as to bond.
Thank you for that adjournment. Regarding bond, I understand there are rules about bond in these kinds of cases. However, we're asking the court to lower this to a personal bond if you would consider it. Mr. Williams is a hardworking man. He works full-time as a production supervisor, and that is important for him to continue making payments. We do have an order from the court, the circuit court, stating that income withholding began at the beginning of the year. So
beginning when?
At 2025, January 2025. So he wants to continue working so that he can continue making these payments.
What do you have as bond?
And I do have that order if the court would like it.
It's $2,500 cash as a second.
But that's just an order of income withholding.
Yes, Your Honor.
Yeah, if I may, when the court's ready.
Yes.
Yeah, thank you, Judge. I saw that order also and found it fascinating that an income withholding order was supposed to start January of this year. We have not shown any payments in this case for 2 years, since August of 2023. So apparently there may be a violation of that first order. But the bottom line is, Your Honor, the statute clearly provides what the bond, recommended bond should be. $2,500 cash in a case like this is not that excessive. As indicated, we see no indication of payment since August of 2023. So if he has been working, he certainly hasn't been paying his support. So we ask that the court continue the bond as currently set, Your Honor.
Your Honor, this is part of the reason for the adjournment. I'm not sure if there's a miscommunication, but I certainly intend to seek out further information regarding this. Mr. Williams strongly believes he's been seeing these payments coming out of his paycheck. He believes it's been 30% of his after-tax income. So we're seeking more information regarding that, and we ask the court to allow.
Yeah, but one could really see that clearly, particularly if it's been coming out since January. I mean, I could see maybe recent payments not showing up on the system, but from January, if he's been compliant with that income withholding order, those payments would have shown up. And then would have been transferred to the victim in the case, and so she would have received payment.
And I don't know that she hasn't. We just need some time to get more information regarding this. We're asking for him to do that.
Ma'am, we can find that. Have you received payments?
Not in January, I did receive a payment from him, in the month of July, the month of June.
June and July, you received payments.
Yes. I received a payment on July, most recently on Monday, July 28th.
Okay, without I don't want to know the amount, but were those basically single payments, or was it a huge lump sum payment?
It was a payment of $400. I don't know if that was a single payment or lump sum.
How much is the income withholding order?
I don't believe it states a specific amount. I believe that his obligation is around that amount per month.
Around 400 per month?
I think it's
So
the information I have, Your Honor, is $950 a month in child support.
you said
950.
900
950, right,
per month.
per month.
And so for at least one of the months, she's only received 400. So I don't know how he's in compliance with that order, and certainly would be in compliance with this one. I mean, if the payments were being received, then certainly that might, and for whatever reason, not credited. I don't know, but that doesn't sound like that's the case to me. So so I think that the bond is appropriately set, and irrespective of that, even if those payments that she's indicating are credited, he's still 8,000, well, he's still 9,000 in the hole. So I'm not going to change the bond. Motion for bond reduction in this matter will be denied.
Thank you, Your
Bond
Honor.
will continue. All right, thank you. Thank you, ma'am. I guess it's good you came down. Okay, I didn't have the answer, but you did. All right, thank you. Court does call the case of the people versus Riel Boyd.
Allie Zend on behalf of the people, Your Honor.
Ready, Your Honor. Robert J. Cole on behalf of Ms. Boyd is approaching the podium. Did you state your name here?
Priya Boyd.
Judge, in this matter, can we set this matter for exam?
Exam.
Yes, please.
Discovery is complete.
Yes, Your Honor.
Your Honor, it's everything we have is given to Mr. Kilwell. He made me aware of something that he was looking for. I don't know if it exists or not, so we're gonna reach out.
We're fine.
And if we should have it by exam if it exists.
We're good with
That
that.
was extraordinarily cryptic.
We don't want to upset Your Honor. We're ready.
I'm not, why do you think what are you gonna do, Kilowell?
We'd like to set it.
You're looking to upset.
Judge, you're a compassionate judge, you know that. And we just want to set it for exam.
I'll do that.
Thank you, Judge.
I'll indicate that discovery is complete. I don't know what you guys are doing. Would you have your witnesses available the 19th?
Yes, Your Honor.
Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, Ms. Boyd. Court does call the case of the people versus Devontae Owens.
Morning, Your Honor. Please, Honorable Court, Brandon Bird on behalf of Devontae Owens. Mr. Owens, can you please state your full name for the record? Devontae Lawan Owens.
I'm wondering if you can also call Ms. Adonis Sweat, their co-defendants.
Why is she yelling at me to call it? I'm not, he's in custody? I'm not bringing another person out. Mr. Childers did apprise us that they were co-defendants, but that they were requesting adjournment, so I don't know why they need to be called together.
Okay.
But thank you for interrupting.
Correct, Your Honor. I need an adjournment, please. I'm gonna at least need at least a month.
A month.
Maybe more.
September 11th, right?
September 11th is good.
Well, you don't know, but all right. Probable cause conference, September 11th, 2025, 9 a.m. Bond will continue. All right, thank you. Court does call the case People versus Hannah Smith Seeley.
APA Richard McDuffie for the people.
Your Honor, good morning. Joe Simon appearing by Zoom for Miss Smith Sealing.
Oh, I'm sorry, Mr. Simon. Hi.
Hello, Your Honor. We switched the time and your staff was gracious enough to allow me to appear by Zoom so that I could make it.
Yes, sir. All right, what are we doing on this case?
Your Honor, the parties have reached a resolution of the case. You should have a plea form in front of you. However, there's a couple things to update the court on. That my client had a single instance of a scram tether violation. She's been on since May 27, 2025. On one date, that being July 12, 2025, she had numbers. Community Corrections asked my client to report everything she did that day because she insists she did not consume alcohol. The only thing that she could report was that the landlord had an industrial service, or not, I mean, a service come in and do carpet cleaning. She has a toddler that's 1 year old, a toddler that she plays with them on the floor. That's the only explanation she could offer. Community Corrections did not think that that was accurate, and that's how we're here. The people have, excuse me, my client was screened and accepted into the 15th District Court Sobriety Court. Ms. Johns of the Sobriety Court is aware of this violation. She will still take my client. My client still wants to go to Sobriety Court. And if we can resolve the plea today, as indicated on the plea form, by the way, I forgot to check the guilty box on that form. That's my error. I apologize. We asked the court to allow that to happen. And I told Ms. Johns that court runs on Fridays, as the court may know, the 15th District Court Sobriety Court. When I originally, this was on the 3 o'clock block, I told Ms. Johns that by the time my client, if your court released my client, that by the time she got tethered again, she would never be available for Friday. But now that we're on the 9 o'clock block, that could happen. And if the court allowed that privilege, I'll do what I can to make that work out.
So she would be appearing at the sobriety court tomorrow morning, you're indicating?
Well, she won't be officially accepted until there's a sentencing. But
right.
I'm sorry, that's not true. She's accepted, but she won't be a participant officially until she's sentenced. But I think Ms. Johns would want her there tomorrow if she was able to be there tomorrow, and my client would go tomorrow.
Okay. Any response from the people on that? All right. So I've checked the guilty box, also the sentencing judge waiver, because this is not my case. But I presume you went through that with her. Mr.
I did,
Fumble.
Your Honor.
All right. May I have her sworn?
You solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so you got.
Yes.
Lower your hand and say, and then spell your name.
Hannah Smith Seeley.
All right. Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating with a high BAC second offense. Is that correct?
Yes, Your Honor.
All right. That's a misdemeanor punishable by up to a fine of $1,000, 5 days to 1 year in jail. The court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
I should also advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before a judge. Hello. Who is my 15th District Court judge?
Judge Moore does the sobriety court.
Judge Perry. Well, we have to do it by the numbers. This is a Perry case? Yes. All right. You'll be sentenced before Judge Perry in the 15th District Court. You understand that, ma'am?
Yes, Your Honor.
All right. So to that charge, how do you plead?
Guilty, Your Honor.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
You have any questions regarding any of those rights?
No, Your Honor.
you'll see on the podium, I need you to look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
As soon as I can find my paperwork. On July 31st, 2024, at the location of Washtenaw Avenue near East Stadium Boulevard in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consumed intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
I had a substantial amount, Your Honor.
Okay. Were you stopped by the police or was there an accident?
There was an accident.
What happened?
I,
Your Honor, my client was badly injured. She doesn't really know. Her car struck a pole. That's really why she can't quantify the alcohol. You'll hear in a minute that the BAC by blood was 0.336.
So you know that you hit a pole. All right.
yes, Your Honor.
But all right. So at some point, ma'am, you're not going to dispute you were taken to the hospital, correct?
Yes, Your Honor.
All right. And at that point, there was a blood test. You're also not disputing that.
No, Your Honor.
And you're not disputing the right of the police to take you to the hospital and have a blood test taken,
No.
correct?
Correct.
All right. And the results of that blood test, as your counsel has indicated, is 0.336.
Yes, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Had you previously been convicted of operating while intoxicated on or about April 16, 2014 in the 14B District Court of operating while intoxicated and or operating while impaired on or about December 1st, 2022 in the 14B District?
Yes, Your Honor.
All right. Ma'am, I do have to advise you, because there at least is an agreement regarding sobriety court in this case, that if you were to commit misconduct between the time of my acceptance of your plea and the time of your sentencing, that first of all, you would not be permitted to withdraw your plea. And secondly, that any sentence evaluation or recommendation, the court would no longer be bound by. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I don't know about the people.
No, Your Honor.
All right. And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. I'll set sentencing in this case and you guys can work around what you'd like to work around, but sentencing,
Sentencing will be August 28th at 8:30 a.m.
August 28th, 2025, 8:30 before Judge Perry. That's the time that we have. With reference to bond, any response from the people?
Your Honor, I just want to make sure I'm clear. Counsel is requesting her to be released on PR bond in the hopes that she can be seen at 15 tomorrow.
No.
Well,
I'm
he
sorry.
wants her bond reinstated.
Yes.
Which means she would have to go back on a tether. And then the hopes is that she'll be out. She would attend at least something regarding the sobriety court tomorrow. Although not officially participating.
Yeah, and I'm just going to try to make that happen. I can't guarantee that it will, but yes, she's already attended and observed. But I know that after this disposition, I will inform Ms. Johns, and if it can happen, I'm pretty confident she'll want her to observe again.
I understand. The people, quite frankly, don't buy the explanation regarding the reason for the scram tether violation. But I also understand that due to the circumstances of her transferring, we don't necessarily need to hold a whole hearing about it, essentially. So the people defer to the court. I am certainly requesting that her bond be reinstated with that scram tether.
Can I say something?
Pardon?
Can I say something?
Want to say something? Go ahead.
I still have the tether on.
You
Oh.
still have a tether on.
Yes.
I made a wrongful assumption. Well, that makes things a little bit easier. I'll notify Ms. Johns right away.
All right. What time is sobriety court?
It usually
8
runs
a.m.
8 a.m.
What I will do is I will grant the defendant's motion, reinstate her previous bond, but that reinstatement of her previous bond will not take effect until 12:01 a.m. on 8/8/2025, since she already has the tether on.
So, Your Honor, I'm just, if that means that she'll be held through 12:01 a.m. tomorrow, correct?
Correct.
I
She can
did,
then get herself somehow down to Ann Arbor by 8 if she's going to attend that session.
okay. That would be a little more difficult. We'll try to make that happen. I
It
just,
shouldn't be difficult. She can walk to Ann Arbor by that time.
Thank you, Your Honor.
I know you could, and you're much older than she is.
Well,
So-
not at present, but thank you, Your Honor.
Okay, all right. Thank you.
Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie Court watch quick as a flash.